Hello and welcome to SEO's breakdown of Day 11 arguments in the challenge to the application of Article 370. On Day 11, Solicitor General Tushar Mehta continued his arguments in support of the abrogation of the provision. He argued that Article 370 gave the people of Jammu and Kashmir a different set of rights from the people of the rest of the country. He began listing what he called shocking differences in the application of the Constitution to Jammu and Kashmir and to India. Entire parts of the Constitution were made inapplicable to the state. This included parts of the Constitution on directive principles of state policy, the states, union territories, and the scheduled and tribal areas, and the 5th and 6th schedules. Second, the words socialist, secular, and integrity from the preamble of the Constitution were not made applicable to the state. Third, key provisions of Part 3, that is, fundamental rights, were made to apply only partially, taking away crucial rights from the people. It removed references to scheduled tribes in Article 15.4, disallowing the recognition of STs in Jammu and Kashmir. It redefined reasonable restrictions under Article 19, allowing the state legislature to set its definition until 1979. Articles 20, 21, 22, 31, 31A, and 32 were applied with modifications. Articles 21 and 22 are the heart and soul of Part 3, Mehta exclaimed. Chief Justice D.Y. Chandrachud reminded the Solicitor General that he was arguing on behalf of the same government that had made these modifications. Without skipping a beat, Mehta responded that the government has a right to correct its mistakes and that he was justifying the undoing of their mistakes. Mehta said that it was unfortunate that some people of Jammu and Kashmir believed in the value of Articles 370 and 35A. He said that after the abrogation of Article 370, investments and the tourism industry have boomed in the state, and employment and income have increased in the region. He then moved his arguments towards the interpretation of the Constituent Assembly. Mehta argued that in the context of Jammu and Kashmir, the term Constituent Assembly always meant Legislative Assembly, and that it was used interchangeably in a floating way. He elaborated that Jammu and Kashmir was already a part of India under Article 1, which describes India as a union of states. Therefore, the Constituent Assembly could never have created a constitution when the state was already bound by another constitution. So Mehta concluded that the Jammu and Kashmir Constituent Assembly was merely making a legislative enactment, just like any legislative assembly would do. He then read out speeches by former Prime Minister Jawaharlal Nehru, where he said that Article 370 is part of certain transitional provisional arrangements. It was not a permanent part of the constitution. He also referred to statements made by former leaders from the state and representatives in the parliament to argue Article 370 was intended to be temporary. C.J. Chandrachud interjected to remind Mehta that these were just views of individual members of the parliament and not the collective decision of the parliament as a body. Mehta tried to convince the bench that this was how the members of the parliament understood Article 370 and chose to leave it at that. The petitioners had earlier argued that the union had played a fraud on the constitution while abrogating Article 370, as they had suspended a proviso to Article 3 when the state was under president's rule. This allowed the union to reorganize Jammu and Kashmir into union territories without reference to the state legislature. To this, Mehta argued that this is a constitutional practice to suspend Article 3 and its provisos when a state was under president's rule. The reason, he clarified, was that under president's rule, the legislature of a state is suspended. Therefore, any provision that requires the consultation of the state legislature also stands suspended. Parliament assumes the role of a state's legislative assembly and makes laws for it under president's rule. C.J. Chandrachud asked Mehta why the suspension of Article 3 was necessary at all if Parliament could assume the powers of the legislative assembly. Mehta responded that this was a way to ensure that in the event that a legislative assembly was only in suspended animation, it could not reconvene and do anything. Presumably, the solicitor's justification seemed to be that this is a way to avoid complications of the Legislative Assembly coming back and passing a resolution against the decision of the Parliament. Mehta sought to discredit the arguments made by senior advocates Kapil Sibal and Nithya Ramakrishnan against the governor's powers to dissolve the Legislative Assembly in Jammu and Kashmir back in 2018. He stated that without an actual plea filed against these events, any argument made against it was just a political attack. This ruffled some feathers in court, with Sibal vehemently insisting that he never made a political argument in this court. These were the highlights of Day 11. Visit seobserver.in for a detailed report on the day's hearings. Make sure to follow us on Twitter, where we give contextualized live updates. You can also subscribe to our daily WhatsApp updates. We promise not to spam you. We'll just start your day off with the most important updates of the day at 9 a.m. sharp. Thank you for watching SEO Daily.